Hello, everyone. Welcome to our presentation today on advanced directives and financial planning. For those of you who don't know me, my name is Kristen Fleming, and I am the Regional Coordinator for Education and Training Services for the Alzheimer's Disease Caregiver Support Initiative. No, that's a mouthful. Um, we have a grant from the New York State Department of Health to provide services for caregivers in 6 counties. They are Clinton, Franklin, Essex, Warren, Washington, and Hamilton counties in northeastern New York. And our main office is located out of the Center for Neurobehavioral Health at SUNY Plattsburgh here in Clinton County. Although we also have an office down in Queensbury, and we have care navigators who work out of all of the counties that we cover. Today you are in a listen only mode. That means I can't see or hear you. However, I am more than happy to answer questions. So if you do have any questions, feel free to type them into the Q&A box or into the chat box. And you can do that throughout the presentation. I'll try to answer them. And definitely at the end, we'll have time for question and answers. So let me go ahead. There we go. I just want to start out by saying I'm not a lawyer. I'm not an expert on financial planning or advanced directives. So if you have really specific questions, you may be better off talking to a lawyer, and I have a few options that I will discuss later on in the presentation. However, if you have questions that I may be able to answer them, I'll do my best, or I'll point you in the right direction. Now, let's just start out with some of the basics. What are advanced directives? Well, they're documents that allow you to state what your end of life decisions are. They allow you to specify if you would like to have any life-sustaining measures taken. They also allow you to determine who you want to make medical decisions for you in the event that you were unable to make them for yourself. Now, financial planning allows a person to decide how assets and their estate will be taken care of upon their death. Why? Why is it important to have these? And I think it's important for everyone to have these, no matter their age. I'm 30, I should have one. Because emergencies can happen at any time. They're often unplanned. Even if you don't have a serious illness, having your papers in order can make emergencies go smoother, and having your advanced directives in place allow you to state what end of life decisions you want or wouldn't want done. So everyone wants to have choice in these matters, and you want to make sure the people that you're closest to know what your wishes are so they can make those decisions for you. If you've been diagnosed with a neurodegenerative disorder like dementia, then it is better to get the legal documents in place before you enter into the later stages of dementia, where you're still able to make decisions. In fact, with some legal documents, you have to be able to be determined to have capacity in order to sign them. So by having them signed in the beginning stages, you don't have to worry about having capacity. So what is advanced care planning? Well, advanced care planning allows a person to state what medical preferences he or she has if you were unable to make healthcare decisions. Many people think that advanced care planning is more for people who are older in age, like I was saying before, when in reality, a medical crisis can happen at any time. There are two main parts to advanced directives: a living will and a durable power of attorney. Some people are hesitant to do an advanced directive because they're afraid that it will take away their choices. However, healthcare professionals will not look into your advanced directive unless it's been determined that you are incapacitated or unable to speak for yourself. By thinking about some medical decisions that would need to be made in an emergency situation or at the end of life and documenting your wishes, you can make sure that your values and your beliefs are thought of. Also, as things in your life changes, You can change your advance directive to reflect your new wishes. Some end-of-life decisions that you want to consider are, do you want CPR performed? It's used to restore your heartbeat if it stops or if it has a life-threatening abnormal rhythm. Ventilator use, or machines to help you breathe. This is when a tube is put down your throat into the trachea or windpipe, and the machine forces air into your lungs. While the tube is in your throat, you're kept sedated and unconscious. Artificial nutrition and hydration. Sometimes if a person's not able to eat or drink, doctors may give them a feeding tube or liquid IVs to provide them with nutrition. And comfort care, anything that can be done to make you more comfortable and stays within your wishes. This could be done by helping with anything from nausea to pain, anxiety, constipation, taking medications for those, providing spiritual or emotional counseling, limiting medical testing, offering ice chips. There's a wide range of comfort care options that you can ask for. This treatment can be done through hospice. It could also be done at home, in a nursing home, or in a hospital. So anywhere that you really may end up being. To get started, you want to think about what kind of treatments you would like in an emergency. Sometimes talking to your doctor can be helpful because your current health conditions may influence your decisions. Also, if you don't currently have any health conditions, thinking about your family history and talking to your doctor about that may help as well. It's important to think about your own personal values. Think about how you live your life and how you would be okay living your life. For example, would it be okay if you were had an illness or an accident, and that left you paralyzed or in a permanent coma? What would you like to happen in those cases? Think about what makes life meaningful to you. For some people, they would be okay undergoing life-saving measures if that meant they were well enough to spend time with their family, even if that emergency left them unable to do much more than listening to books on tape or watching animals out the window. Some people want to stay alive for as long as medically possible. Your outlook on these decisions can change throughout your life. Age and incurable conditions can help impact these decisions. A living will is a legal document that tells your doctors how you would like to be treated if you were dying or left permanently unconscious. You can determine in a living will which of these life-saving measures, so CPR, ventilator, artificial nutrition and hydration, and comfort care, you would like done. You can also determine the condition under which you would like each one done or not done. So you can make stipulations. It's not like you are locked into one or the other. Durable power of attorney for healthcare is a document that names the person you would like to make healthcare decisions for you in the event you are unable to. This person is often referred to as a healthcare proxy, but it sometimes can be called a representative, a surrogate, or an agent. The person you choose should know what your values and wishes are when it comes to end of life or emergency treatments. Some people do not want to put their health decisions in writing. If they have a healthcare proxy, then the person can make decisions based on the situation and the treatments available. Having a healthcare proxy can be done with a living will or in place of a living will. DNR stands for Do Not Resuscitate. This tells staff at the hospital or nursing home that if your heart stops or doesn't have a normal rhythm, that you would not like CPR done. Even if you have this listed in your living will, a separate DNR order is helpful as it can be placed by your bed or if you're in a nursing home or a hospital. Or if you're at home and there is an emergency, Having one posted on your refrigerator can be helpful for emergency staff to know what to do in regards to CPR. You also, if you do not wish to be intubated or you have a breathing machine, then there is a D&I order you can sign. At the end of life, if a person is overall healthy and a person's tissues and organs may be donated to another person who is in need. Usually these include heart, lungs, pancreas, kidneys, corneas, liver, and skin. There isn't an age limit to being able to donate. When a person passes, the family members may be asked if they wish to donate the organs. It can be helpful if they know the wishes, especially if they are your healthcare proxy. There is no cost to the family for organ donation. Also, if a person has requested a DNR, but at the same time wants to donate, they can make the stipulation that the organ donation comes before the DNR, as in some cases, the person may need to be on machines until the organs are ready to donate. When it comes to choosing who your healthcare proxy should be, think of a person who shares your values and beliefs about life. It could be a family member, a friend, or attorney, or someone from your church. It's a good idea to name an alternative healthcare proxy as well, just in case. If you decide not to name a healthcare proxy, it's important to have a very detailed living will. You are able to choose how much control your healthcare proxy has over your medical care. They can be able to make decisions freely or only in specific areas. Try not to have too strict of guidelines that may make it difficult for them to fulfill their job. Talk to the person you're listing as your healthcare proxy to make sure that they are comfortable with the job. After you've talked to your doctor and learned about the types of decisions that could come up at the end of life, and you've selected who you would like for your healthcare proxy, it's time to make it official. You can choose to go through an attorney if you would like, however, it is not required. Also, if you decide you would like to go with an attorney, you shouldn't depend on them to help you understand the medical treatments. Most states have their own advanced directive forms. You can find one by going online and printing one there. You can also ask your doctor for a form, as they may have one in the office, and your local area office for the aging may have some as well. Depending on your state, you may need to have your advance directive witnessed. However, in some states, you need to have a notary witness a signature. You can find a notary at the bank, post office, town office, or library. In New York State, you simply need 2 witnesses who are not the healthcare proxy or the alternative proxy to witness you signing the document. If you are someone who spends a lot of time in another state, you may want to think about having a healthcare proxy completed for both states. Be sure to keep copies of both in each place. After you've made your advance directive official, you need to give copies to your healthcare proxy and alternate proxy. You should also give copies to your doctor for their records. It can be a good idea to tell some family members where you've kept your copy of it. If you go to the hospital, bring a copy for your file as well. Keeping a list of who you gave the advance directives to is a good idea, as you may decide to change it and will need to update all of those people. It's a good idea to review your advance directive every 10 years, or if there has been a major life change, such as divorce, marriage, illness, or one of your healthcare proxies passes away. If you change your mind on your preferences, be sure to let your doctor and your proxy know. In the event of an emergency and you don't have a healthcare proxy, the state will assign one to you. In most cases, it would be your spouse, parents, or children. However, if you have no family members, then the state would assign someone to you. Now, before we move on, I do want to share this document with you. It's called 5 Wishes. And normally I give out books with all of my presentations. With this one, I give out this handout instead of a book. It's from Aging with Dignity. And this is actually a healthcare proxy kind of almost like a short workbook. It has really great questions. So it starts with the person you want to make care decisions for you when you can't. Then it asks what kind of medical treatment you want or don't want, how comfortable I want to be, how I want people to treat me, and what I want my loved ones to know. It's recognized in 42 states. So you could use this as your healthcare living will. New York is one of those states that it is recognized in. And even if it's not recognized in your state, if you live in another state, I still really recommend people fill this out with their healthcare proxy because it asks such detailed questions. It's a really good form. And then you can fill it out and you also have the regular state form that you need signed. If you would like me to either mail or drop off a copy or a couple copies of this to you, please let me know. I'm happy to do that for you. Before we move into financial planning, does anyone have any questions about healthcare, advanced directives, or your proxies? Okay, no questions? Well, if you think of anything, please let me know. We'll keep moving along. So financial planning, it includes your will, your power of attorney, and your living trusts. It's important to start talking about your finances early after a diagnosis of dementia. The rate of a person with dementia declines varies from person to person. So this will mean that they will become less and less likely to be able to be involved in the planning. Sometimes people are not in the early stages when they're diagnosed, and that can make decision making even more difficult. If there are life events that happen, please make sure to review the plans. This could include death, divorce, moving out of state. A will is a legal document that allows you to state who will manage your assets or your estate when you pass away. Your estate includes everything you own from homes to small sentimental items. In a will, you name the person who will manage your estate or the executor. They are the person who will see out your wishes. In a will, you can state what you would like to do or who you would like to become the guardian if you have minor children or disabled children. In addition, you can state who you would like to receive specific items that you have. Anyone who's receiving property is called a beneficiary. Retirement accounts and life insurance policies are usually not covered in the will. These accounts should have a person or persons listed separately as the beneficiary for them. If you are unsure of who took care of this when the accounts were started, you should look into it by calling those companies. So what if there isn't a will? Well, if a person passes away without a will, the estate will have to go through probate. Probate is a legal process where the estate will go to its rightful heirs as outlined by the state laws. And it's important to know that state laws do vary. In probate, because no one has been assigned to follow through your wishes, the state will assign an administrator to follow through with the laws. If the will left behind does not meet regulations or requirements the state has for wills, there will also be an administrator assigned. Because the administrator is bound by the laws and is a stranger, they may not make decisions that you would agree with. Should I use an attorney for my will? You do not have to hire an attorney to prepare your will. Attorneys can provide useful information on estate planning. However, as long as a will meets the state laws, then it is a legal document no matter how it is prepared. You can find kits to put together a will yourself. They are available online or there is software for it. Libraries and bookstores have do-it-yourself guides. Also, local areas on the aging may be able to direct you to low cost or even free resources for estate planning. So, if you live in New York State, definitely call your OFA, your Office for the Aging. I know in Clinton and Essex counties, you can go to the Rural Law Center if you're over 65, and they will help you with this for free. I do also believe that they have a sliding scale. So if you're in Clinton or Essex, call the Rural Law Center and see what you're qualified for. If you're in other areas, I would recommend calling your county's Office for the Aging and see if there is a grant or a program that can help you with it. It's recommended that spouses have separate wills. In fact, some states won't even recognize a joint will. Spouses do not usually pass away at the same time, and there could be property or assets that are not jointly held. It's not uncommon, though, for spouses' wills to look very similar. Anyone can witness your will. However, it's a good idea to make it someone who is not a beneficiary in the will. This could be an area where someone may claim that there was a conflict of interest. In some states, you need to have 2 or more witnesses. In some states, it also needs to be notarized. So look into what your state requirements are, especially if you're doing this on your own, you're not going through an attorney. You can name any trusted person as the executor or the person to carry out your wishes. It can be a spouse, a child, or if your affairs are complicated, it may make sense to appoint an attorney. You can name joint executors, such as your spouse and your attorney. You may want to think about allowing your executor the ability to pay your bills. Contesting a will is when a person challenges the legal validity of a document. This can be done by anyone who believes that this goes against probate laws or maybe a beneficiary who feels slighted. Wills can be contested for many reasons, such as it wasn't witnessed correctly, you weren't competent when you signed it, or that the belief that it was a result of pressure or fraud. When this happens, it's up to a judge to decide if the will is valid. To ensure this doesn't happen to your will, it's important to have a clearly written will that follows the laws, the correct state laws, for it to become a legal document. If you would like specific items or property left to certain people, state so in your will. You can also create a letter of instruction to keep with the will. A letter of instruction can go into detail about which and possibly how many items you would like to go to what person. You could also leave everything to one trusted person who knows your wishes, and that person would then distribute your things. Consider this choice very carefully. Your will should be updated anytime there's a major life change, such as divorce, marriage, birth of a child, the death of a beneficiary, or a large purchase that you want included. The general rule is to review your will every few years to ensure you don't want to change anything. A living trust gives someone the responsibility for managing your property. These written agreements happen while a person is still alive. And as long as they're still mentally competent, they're able to change or dissolve the trust at any time for any reason. A living trust is no longer able to be changed, though, when a person passes away. Living trusts and wills are very similar. They both leave directions for what you would like to happen to your assets upon your passing. Living trusts tend to be more for a person with a larger estate. Living trusts are often more private as well, as they do not need to become part of public record. However, sometimes a trustee or a beneficiary demands the courts to approve the account. Living trusts do also tend to be more expensive and are more complicated than a will. With the power of attorney, you appoint someone to act for you in certain situations. It is a legal written document. You're able to choose how much power you would like the person you appoint to have. They can have access to your bank account, the ability to sign income taxes or sell stocks, or they can only have the ability to act for you in certain situations. You are also able to decide when you would like the powers to start and end for your agent, for the person that you're appointing. Now, there's a few different types. Conventional one starts when you sign it, but it ends when you are incapacitated, when you are no longer able to make decisions for yourself. So this people can run into problems if they have a conventional power of attorney. A springing one starts when a certain event happens, such as you becoming incapacitated. This type of POA does have to be carefully put together to prevent any difficulties from determining when the springing event happened. A durable power of attorney can be the best choice for people. It starts when the document is signed and ends and stays in effect unless you cancel it. It stays in effect even if the person becomes incapacitated. So unlike the conventional POA, it stays in effect. Even if you determine who will be your power of attorney, you're still able to manage your finances on your own. So it doesn't take away your abilities to manage your finances. When or if you become unable to manage your finances on your own, that is when your agent or your power of attorney will step in. When you pass away, all power of attorneys end. Now that can be confusing, so please let me know if you have any questions about that. I know I had to think about that a few times through. Who should you choose? When it comes time to choosing a person or an agent, it's important to choose someone that you completely trust. This person should be able to handle the responsibility. When you choose a person to be your agent, you should name an alternate just in case the first is unable to fulfill the obligation. It's a good idea to have your attorney review all of the paperwork to make sure it meets state requirements. Once your paperwork has been written and signed, bring a copy to all of your financial institutions. If you would like your agent to handle your banking, you should talk to your bank about getting an authorization form and a signature card for the agent. This is different than being a joint account holder. The agent's able to withdraw money for your benefit only, and when you pass away, the remaining money will be added to the estate. Your agent does not actually own any of your assets. He can only make decisions when you are unable to. You are able to revoke or change the power of attorney at any time. You can name a new one in a new document or simply write a statement stating you would like to cancel it. If you choose to revoke the power of attorney, you should notify the agent. Once you appoint an agent, you should sit down with them and talk to them about all of your bank accounts, loans, credit cards, and other financial pieces. So how do you get started? Well, you want to figure out first, do you want to do it yourself? Do you want to go through an elder law attorney? Do you want to use legal aid or rural law center? That is up to you. That brings me to the end of my presentation. This one is a shorter one, but I feel like there's a lot of information in there and it can be confusing. So if you have any questions, please let me know. I'm also happy to mail a copy of our slides or drop them off to you along with this 5 Wishes booklet. So if that is something you are interested in, please let me know. And if you have questions at this time, feel free to type them into the Q&A box or the chat box. I do want to let you know about a couple of upcoming events while I'm waiting to see if there are any questions. So the first one I want to let you know about, next week we have our last presentation in this series. It's going to be on caregiver quality of life and self-care. It's one of my favorite presentations that I give because I think self-care is so important. A lot of times caregivers do not take care of themselves. but you can't care for someone else if you're not taking care of yourself. So you need to be prioritizing your self-care, and, going to your own appointments and taking care of yourself, eating healthy, exercising, all of those things. So I really love that presentation, and I will send you all the link for that. I'm also doing a series starting in April, and this one's different. It's going to be the powerful tools for caregivers presentation, educational training. So that is a formal training. You get a certificate of completion and you get a book that comes along with it. It's really great opportunity to connect with other caregivers, share your stories, learn practical tools. So if that's something you're interested in, please let me know and I will get you registered for that. And finally, we are doing more virtual caregiver conferences. So if you've been involved in our program for a long time, you know that last year we started doing these virtual caregiver conferences. And our next one is going to be on April 14th at 1 p.m. We're going to be doing a panel discussion with our staff, as well as a keynote speech from Frank Pastizo, who spoke last year. He's a wonderful storyteller. He's been actually caregiving for his mom, and he also has some experience as a professional caregiver. So he has a lot of wisdom to share with us. Like I said, if you're interested in any of those programs, please let me know. I'm happy to get you the registration info. Yes, I'm happy to mail you a copy of the workbook. Who decides when you're no longer able to make decisions for yourself? That is a great question. So a lot of times, if you were meeting with an attorney, or with a doctor, they will determine competency. So sometimes, especially with dementia, people will have good days and they'll have bad days. So you could have a good day and have capacity to be able to sign it, or maybe you're having an off day and you don't have capacity to sign it, but you go back a few weeks later and you're doing better. So it's really up to the attorney or to the doctor when you're signing those forms, and to the witnesses, the people who are signing it, who are agreeing that they were a witness to you and to your family to a certain extent. Great question. Are there any other questions? Well, if there are no more questions, I want to thank you all for coming to my presentation today. If you think of anything else, feel free to give me a call or an email.